Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Marc Halsema walks through a Series A preferred stock agreement. So, let's tear it down. Marc Halsema, thanks for joining us on the Contract Teardown Show. How are you today?
I'm doing terrific. Thanks, Mike.
I appreciate you being here. We're talking about a document. I'm going to share the document with the folks at home real quick. This is a Series A preferred stock purchase agreement. Before we dig into it, Marc, why don't you tell us what this thing is? When are we going to see this kind of a document? Why is it important for us to understand?
Well, that's a great question, Mike. Series A preferred stock agreement usually comes into play when a private company, and all of this is private, is looking to raise venture capital for its company. Usually it comes after a startup company has been running for a couple of years and they've issued common stock, maybe in different classes of common stock, to the founders and the initial officers and directors, and now they're looking for big money. And that's where the Series A preferred stock comes in, because usually that's some type of institutional venture capital investor.
Perfect. And there's a lot to talk about there. Before we dig into it, Marc, tell us about your background. What brings you to documents like this?
I serve as an outside general counsel to families, family offices, successful entrepreneurs, startup companies that are looking to raise capital. And I frequently get involved with drafting these types of agreements on behalf of companies that are looking to attract investment.
That's great. I mean, that's exactly the background that we need to talk about this Series A situation. We can talk about raising money for me later. My wife wants me to go do that, but we'll talk about the ups and downs of that. But before we get there, let's go through the agreement. There's a lot to this kind of, when you're raising money, there's a lot of protection that needs to happen for the person giving money. So let's talk about what some of those are. I wanted to start with ancillary agreements. As I'm looking through the definitions section, going down into page 4 and 5, there are references to several other documents: indemnification agreement, investors' rights agreement, co-sale, right of first refusal, co-sale agreement, voting agreement. Talk to us about these other ancillary documents, how they're being referenced here, and how to make sure that they're incorporated into the party's intentions.
Right, exactly. The purchase agreement itself is sort of the hub of the wheel, as is the case with many types of legal agreements. There are other agreements that sit side by side, and a Series A stock, preferred purchase agreement has a number of agreements side by side. In addition to the ones that you've mentioned, Mike, there's an amended and restated certificate of incorporation. And I'll preface my comments by saying everything I'm going to refer to in this conversation is going to be based on Delaware law. People can choose different laws, of course, but this particular agreement is governed by Delaware law, and so it's some of the ancillary agreements. Starting with the amended and restated certificate of incorporation, it's going to restate the classes of stock and their various rights. Frequently, that will also memorialize how many board seats a venture capital investor will get. The indemnification agreement, that's really about indemnifying officers and directors of the company. In some cases, a director will serve as a nominee of one or a group of directors, but because venture capital funds with director nominees may be named as parties or otherwise incur expenses in connection with litigation against their director nominees, frequently those venture capital funds will want to have indemnification, not only for the individual directors, but for the funds themselves. The investor rights agreement is really just as it says. It defines the rights that investors have for information, registration rights, rights of first refusal, preemptive rights. And I think the more significant aspect of the investor rights agreement is really around registration. Should the company decide it's going to have a much larger private transaction, a private capital raise under Reg D, they want to have a seat at the table. Or if it's going to go public, they want to be involved with the drafting of the registration statement and all of the filings with the SEC. In other words, the investors want to have an active voice at the table. The management rights letter, that's very specific to ERISA. The U.S. Department of Labor, which is charged with administering ERISA, has issued regulations that contain certain exemptions from the plan asset rules. And under one of those exemptions, an investor in a company needs to be qualified as a venture capital operating company. And that means it has to have 50% of its assets invested in venture capital investments. And so the venture capital fund that's looking to invest, several $1 million into a private company will ask the management of the company to issue a letter that the management rights are defined in the letter, and that should there be a question from the Department of Labor regarding ERISA plan assets, they have a management rights letter that shows that they do qualify as a venture capital operating company. The right of first refusal agreement is just as it sounds. People who are existing or new shareholders, if there's going to be an additional capital raise, they want to avoid dilution. And by that, they want to be able to be party to a capital raise in order to maintain their percentage interest in the company. And lastly, the voting agreement. And again, I've seen most of these agreements in connection with Series A preferred stock transactions. The National Venture Capital Association has been good enough over the years to promulgate standard template documents around all these. So frequently I see either in reviewing documents, any of these particular agreements, whether it be the purchase agreement or the indemnification agreement, et cetera, modeled after the National Venture Capital Association templates. And so that makes it very useful because it becomes predictable. But lastly, the voting agreement. The voting agreement sets forth board composition requirements for investors, giving them their rights and in terms of how the board is going to be operated. But also it defines drag along and tag along rights. Drag along rights being the rights that give the majority owners the right to force minority owners to join in the sale of a company, and a tag along right, which is the mirror opposite, which gives co-sale rights. If a majority stakeholder sells a stake, the minority stakeholders, they want a voice at the table as well. So in addition to the agreement that we're talking about today, Mike, frequently in these kinds of transactions, you'll see any or all of these ancillary agreements that I just described.
Well, and I wonder, maybe this is a basic question, but as a drafting exercise, is this the way to do that, to incorporate these other documents through the definitions section? Do you like this approach, or is there a more transparent way, or maybe a more efficient way to do that? What do you think about them being plugged into the definitions section like this?
Well, I think it's important to have them front and center, because not only are they in the definition section, they are also frequently exhibits to the main agreement. As I mentioned earlier, the purchase agreement itself is really the hub of the wheel, and you have all these various agreements that are side by side, and all of which fit together like a puzzle, if you will.
Right.
And
so
I
you're
think
kind
it's
of
important.
identifying what all the spokes are, and so you got to make sure. And the nice thing about a definition section, to your point, is it's up at the top. And so if you set out those spokes early, that makes a lot of sense. Well, let's jump down to section 2. It is the representations and warranties section, which I assume is a big part of this, because that transparency is really the value that the money giver depends on. We'll start with 2.4 authorization. There are some limits here. Talk to me about the reps and warranties section and 2.4 specifically.
Well, reps and warranties generally are a long laundry list of statements that a company will make about its financial condition, its business operations, its current status of litigation, its key employees, et cetera. I mean, it is a list that will go on several dozen sections. I chose authorization and litigation simply because those are the ones that frequently can be litigated if something goes haywire in one of these transactions. The authorization is simply a representation that the company has all of the right authorizations to amend its certificate of incorporation, issue the new stock, and it will also set up some guardrails within the authorization section that indemnifications can come only through the indemnification agreement or the investors' rights agreement. So I chose authorization because there's a textbook example as to how these ancillary agreements, the hub and spoke documents in this transaction, come into play. The litigation section 2.7 rep and warranty is it's an unqualified litigation representation, meaning there's no litigation. flat out full center in a Series A offering is rather typical, but it may be different in a later financing because transactions become much more complicated.
Yeah, I'm wondering about the pending or to the company's knowledge or currently threatened. I assume that sort of knowledge goes to those key employees as well. So the representation is coming from the chiefs, that are signing this document, through the lawyers. But to the point here that it also can't be against any director or key employee of the company. Their knowledge, I assume, is imputed in that as well. Well, representations and warranties get long, presumably, in a document like this because, that transparency, again, is really important to the company giving money. But I know that you are seeing some stuff missing from this section that we might put in here to protect that transaction. What kind of sections might you also see in the reps and warranties?
Any number of them, particularly if an investor is a foreign company. But even if the company is not a foreign company, one of the investors is not a foreign company, you'll see certain reps and warranties. None of the reps and warranties I'm about to mention exist in the current document that we're tearing down, but I've seen them in many others, and they're going to be important for a drafter considering this type of agreement. One is around real estate, and this is applicable to FIRPTA. FIRPTA being the Foreign Investment Real Property Tax Act of 1980. This particular real estate representation is appropriate if there are going to be foreign investors, non-resident aliens, for instance, involved in the transaction. And usually this representation will state that there is no FIRPTA, meaning the company does not have any real estate holdings outside the United States, which would trigger a withholding tax situation. Another area that, and again, this is not necessarily for foreign investors at all, is a Section 1202 qualified business stock representation. Section 1202 of the Internal Revenue Code provides for a 100% exclusion from taxable income for gains recognized on the disposition of certain stock held for at least 5 years. And certain companies, and again, this is applicable to startup companies that have been in business for a short period of time, but at least 5 years, that they may be able to qualify for a Section 1202 qualified business stock deduction. And perhaps in this particular transaction, it didn't qualify, it wasn't applicable. But for startup companies that have been in business for at least 5 years, I have seen that quite frequently. With respect to foreign companies or investors that are outside the United States, there are usually at least 3 other representations and warranties that I see in these kinds of transactions. One is a Foreign Corrupt Practices Act representation that the company has not been actively involved overseas, it's not been bribing people, it's not been making payments. It's a fairly easy one for most legitimate companies to make. There's also representation for around export control laws and a representation that the company has adhered to the Office of Foreign Asset Control, or OFAC. And finally, there is a representation that I've seen quite frequently that under CFIUS, which stands for the Committee on Foreign Investment in the United States, that none of the investment is, to put it simply, related to the defense industry. Back in the 1950s, there was legislation passed that made it clear that investment in the United States couldn't touch the U.S. defense industry for all sorts of obvious reasons. My last comment on reps and warranties, and I've seen this countless times, is that depending on the particular rep or warranty, there will be an exhibit or a deliverable or disclosure schedule for each of these different reps and warranties. And so you may have pages and pages of disclosure reps for the issuing company and, of course, for the investor as an addendum to the agreement itself.
I'm curious, and again, this is probably a basic question, but I'm thinking about the nature of these transactions and the power relationship between the two sides, the person who's got the company who's got the money and the company who wants the money. I'm assuming in these kinds of transactions, there's a lot of due diligence to be done, that the company who's given the money wants to know, and good practice would say, go dig, send investigators and find out about everybody's background or whatever. It sort of sounds like they're using the reps and warranties in this kind of document to shift that burden a little bit and say, you know what, I'm not going to do due diligence. I'm just going to make you promise me that you gave me the equivalent of due diligence. Is this, sort of being used as a way to shift responsibility for the digging, or is this just good practice?
You're absolutely right that giving a rep or warranty that we have no litigation, we have no environmental concerns, we've complied with CFIUS and Foreign Corrupt Practices Act, et cetera. And where the reps and warranties come into play, of course, is if there's a breach or if there's a misrepresentation, that obviously can unwind the deal or cause litigation down the road. So the due diligence, there's no replacing the need for due diligence in any of these transactions. And that's usually done, these days done virtually, and you get reams and reams of documents that you have to review. But to cut to the chase, then you have a rep or warranty that you can hang your hat on. If you're the investor, you can hang your hat on. And if there's some screw up or some misrepresentation, it gives you a right to pursue litigation.
Got it. Yeah, that makes a lot of sense. And relevant to that, as we jump down to 813 in dispute resolution, the power structure often comes out in these relationships in the dispute resolution section and who's giving up what. And so I wanted to ask you, in these kinds of contracts, in these kinds of documents, as a background question, who's usually drafting these? I assume that the starting drafter is the company with the money, because they're in a Series A anyway. They're able to pick and choose. Is that accurate? And as we jump to the dispute resolution section, does that reflect the power structure? Are you seeing arbitration-like language, which is common when there's one party in power is the one that's drafting? What's the power relationship between these two sides in this document, and how does that impact this dispute resolution section?
Well, common practice is for the company that's looking to raise the capital will draft the documents as opposed to the company that has the money. So, for instance, in this context, I'm guessing that it was Comstock Mining, or the lawyers for Comstock Mining, that drafted all the documents, and that's rather typical. Either a buyer or an issuer, in this case of the security, will draft the documents, and then the other side gets to pick and choose. As it relates specifically to dispute resolution, I've seen it on the simple side, which means they'll do everything they can under a particular state law to resolve a dispute, and they'll take it to the local courts. And typically there's language that both sides waive a jury trial, and they'll simply take their dispute to court. That's on the simple side. On the more complex side, I've seen situations that require, binding arbitration under the American arbitration rules, or if it's a Delaware company, under the Delaware Arbitration Act. And there you have, each side gets to pick an arbitrator, and then the arbitrators pick a third arbitrator, and it becomes actually quite complex. But usually the common practice is for the issuing company or the buyer in an M&A transaction to be responsible for drafting the documents.
Awesome. Well, as we wrap up, I'm thinking about money raises. I read a book recently that talked about VC world and basically argued that VC world is like going to take the American economy down because it creates these sort of perverse incentives and who's in charge and how they get to dictate. But I read, as I occasionally do, I was surfing around the social science research network and reading academic articles because I was bored this morning. And there was a study done of a group of companies that received money versus a group of companies that didn't. And there was an 85% increase in sales for the companies who received the money. So stepping back from this kind of stock purchase agreement and just the idea of raising money for companies that are in this position, that they've got enough success, that they can raise money. Talk to us about the context of choosing this as a path versus bootstrapping versus some other path, and how you advise companies on making that choice.
I like to go through the private transaction route, depending on the amount of capital being raised. If it's a relatively small amount, less than $5 million, the U.S. securities laws are less onerous in terms of compliance, in terms of a private Reg D transaction. If you go above $5 million, then it becomes, there's a certain additional layer of disclosure that needs to be done. And of course, you have to have accredited investors when you're doing it in a private transaction. When it becomes a public transaction, a SPAC or a public offering, that's a whole other level of disclosure, compliance. Certainly, in terms of the complexity of documents, legal documents that need to be provided. If it's a public company, of course, you have to have a registration statement, and you have to have filings with both the SEC and the state securities regulators. So private is a lot easier, so long as it's a smaller transaction. I mean, but whether it's public or it's private, the overwhelming challenge for a company that's looking to raise capital is not only to identify people who are interested in investing in your company, but what kind of control are you going to give up? Okay, when we talked about some of these ancillary agreements, particularly around a voting agreement and a management rights agreement, we're talking about giving up a certain amount of control of your company to an outside investor. And for a startup company, that's a really important river to cross. So bottom line, private transactions, particularly if it's sub $10 million, but there's always going to be the issue or concern about investor control and how much, and that's really where the negotiation and the horse swapping comes with an outside investor in terms of control.
Well, if my wife finally persuades me to raise money for our YouTube / cat and bird home that we have business, I'll be sure to keep it under $5 million for simplicity's sake. Marc, I appreciate you joining us and this breakdown. If my wife does persuade me to raise money, where do I call you? What's the best way to reach out to you if people want to learn more about your background and transactions like this?
Absolutely. The name is Marc Halsema. The best email address is JACLISE, Jaclise, which is a contraction of my two children's names, Jacob and Elise, at live.com.
Awesome. Well, I appreciate it, Marc. We'll have that information as well as links to this document and maybe even my random SSRN article that I read this morning over at lawinsider.com/resources. And if any of you watching wants to be a guest on the Contract Teardown show and beat up a contract like Marc just did, just email us. We're at community@lawinsider.com. We will see you all next time. Thank you again, Marc.
Thank you, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.